Hello, everyone, and welcome back to No Fear 2A News. I'm your host, John Berger, and today, to lead off our stories, we have a case coming out of the district courts in Paco, Texas. Should people under felony indictment be able to own firearms? That's the big question. All right, so coming out of Paco, Texas, the district court there is a case where a gentleman by the name of Jose Quiros was under felony indictment for burglary. And while under felony indictment for burglary, he filled out a 4473 at an FFL to purchase a .22 handgun, from what I understand. And upon doing so, he lied on the 4473. The 4473 asks if you're under felony indictment or anything like that, and he checked no. Again, this is a blatant lie because he was, which subsequently he later on, passed the background check, got his gun, all that. He ended up being indicted for another felony of, lying on a 4473. So after being charged and convicted with this crime, he asked for it to be appealed under the New York Pistol Rifle Association case v. Bruin. And they started going through that process. It made it up to the district court here in Paco, Texas, and the judge ruled that limiting the rights under citizens of felony indictment is in fact an infringement and unconstitutional. Under Bruin, I prefer to call it the New York State Pistol Rifle Association case, but everybody knows it as Bruin, so call it Bruin, I guess. The government has to argue that there is long-standing tradition and history of what they're trying to continue to infringe upon our rights. And so in doing so, the only thing they could really do is go back to 1938 and say there's a long-standing tradition here because, back in 1938, so what, 85 years? Doesn't quite hold up. So for the last 85 years, persons under felony indictment of violent crimes couldn't own firearms. And then in 1968, that was actually amended to just include anybody under felony indictment. But so there's a couple of takeaways here. One, judge is saying, 85 years doesn't really hold a whole lot of water there. And then the other big takeaway is the fact that if you think about the NFA, they're going to say 1934. So what, 4 years more is going to make for that rich history? No, it's not. But that's going off into the weeds. Anyways, so the judge actually tried to help the case of the government. He said, if there's nothing really analogous to the situation at hand, perhaps we can look at other rights. And the First Amendment, written very similar to the Second Amendment, so he actually looked at the First Amendment and the right of free speech, and he actually helped the case of the defense in this case. And it was actually really awesome because essentially, what he said was, well, if you're under felony indictment, you don't get to say certain things. He's like, no, that doesn't work. If you're under felony indictment, you don't get to own firearms. No, that doesn't work either. So that was kind of the basis behind his ruling here. Now, this doesn't really change anything for anybody except for this gentleman at the moment. But the government has already appealed, and it will be going to the Fifth Circuit. The Fifth Circuit typically is a very pro-2A circuit. Now, it's going to go to a 3-judge panel first. They're going to rule probably favorably, at which point it will get appealed by the government again, go to an en banc panel, which is all the judges. And then once that happens, after the en banc panel, if they still don't like the outcome, then it will probably be appealed to the Supreme Court at that point, which then that could have a wide sweeping effect over everybody across the nation, just as Bruin did. So could be something to keep our eyes on, but it's going to take a couple more years to even get to that point. Now, I'm sure some people out there are going, yeah, but he was under felony indictment for burglary. He's a bad person. He shouldn't have a gun. There's a lot of problems here. One, if he is such a menace to society, he should have never been out on the streets in the first place. However, it's not hard to get a felony indictment. You talk to any prosecutor, talk to any defense attorney, they're going to tell you. And the judge actually touched on this in his opinion about how it's not hard to get a felony indictment. So the fact that you're under felony indictment and you shouldn't have certain rights should not happen. Don't know. In an indictment hearing, the defense attorney is not allowed in. He has no right to be in the courtroom at the time of the indictment hearing. So you just get to stand there while a prosecutor just runs you down in front of a judge, and the judge says, yes, indictment, or no. But, again, there's that old saying, get a ham sandwich indicted. I actually think this judge talked about how easy it is to get a burrito indicted, if I remember correctly. So maybe that's their version of ham sandwich down in Texas. But yeah, so again, going back on this real quick, the idea that, just because this guy was under felony indictment for burglary, he shouldn't have guns or anything because he's so dangerous. If he's that dangerous, he should be locked up. And extremely dangerous criminals do get locked up without bond, things like that. But I am also under the belief that once you have served your debt to society and you have been released from prison, that you should have all your rights back. Your right to vote, your right to keep and bear arms, you name it, you should have it. I realize that is an unpopular opinion, and it's an opinion that is probably split amongst the firearms community. But if you're truly pro two-way, then you should never be saying I'm pro two-way, but, because at the end of the day, that means you are for some sort of infringement. At the end of the day, I just can't get on board with that. The Second Amendment says shall not be infringed, not shall not be infringed, but. So something to keep in mind. Thank you for watching. Hit those like, comment, share, subscribe buttons. Catch y'all later.